Today's topic is Florida Community Property Trust and how they can help folks who live in Ohio. Today's guest is attorney Craig Hirsch from the Shepherd Law Firm in Fort Myers, Florida. Welcome, Craig.
Thanks, Ted. Thanks for having me.
Craig, my understanding is you're a certified specialist in estate planning. How long have you been doing this?
I'm in my 35th year of practice. So, 35 years. And I've been board certified in Florida since I was eligible, which is 5 years in.
Great. Well, look, the Community Property Trust statute is new in Florida, is my understanding. Why don't you tell us a little bit about how the statute came to be adopted, when it took effect?
Yeah, the statute's about 2 years old, 2.5 years old now. The idea behind it is to give residents, or not even residents, you can be, as we'll talk a little bit later, you can be an Ohio resident and get the Florida benefit as well. But it's for people who are of common law states to get community property tax treatment, and that's largely associated with what's colloquially known as the step up in tax cost basis. So we'll talk about that today a little bit.
So the type of asset that this applies to, does this apply to everything that I own, or is it only certain assets?
Yeah, it applies to most everything you own. Real estate, it could apply to a business, a closely held business interest. It can apply to investments, although assets inside of qualified retirement accounts, such as an IRA account or a 401k account, those do not get any step up in basis treatment. But most everything else that you own would.
So we're really talking about what I call capital assets.
Yeah.
And so a capital asset under the tax law has something called basis. What is basis?
Yeah, basis is basically what you paid for it plus any additions. For example, if I bought a residence and I paid $200,000 for it, but then I did an add-on, I added a room for $50,000. My new basis is $250,000, and that's what I paid for it plus what I added to it. And that's a real simple explanation of what basis is.
So what happens if you have that, say, an apartment building that you paid $250,000 for, and it appreciates in value, and then you want to sell it under the tax law? What happens?
So if I paid $250,000 for an apartment building, we're getting cut off there a little bit. So let's make sure that I understood. Why don't you say the question again, and then I'll answer it.
So why don't we talk a little bit about what is basis?
Basis, Ted, is basically what you paid for a capital asset. For example, your residence. If you bought your residence for $150,000 or two, let's call it $150,000. And then let's say you later added a room and it cost you $50,000. Your basis in the property is what you paid for those things, which would then equal $200,000.
So it's what we paid for the capital asset plus any improvements.
That's right.
And that particularly applies to things like real estate or stock or our business assets, correct?
Right. Let's take investments, for example. If I bought an investment, I put $10,000 into a stock holding. And if I was reinvesting the dividends, if I had a DRIP plan, a dividend reinvestment plan, my new basis would be what I paid for that stock plus the dividends that I reinvested.
Very good. Why do we care about that? Why do we care about basis? If we never sell the asset, does it ever really matter?
Yeah, that's called an unrealized gain. And we don't recognize a capital gain. We don't pay capital gains taxes on an asset until we've sold it. And that's when we realize the gain, which is generally speaking the difference between the sales price and our basis.
So once again, if we never sell the asset, then we don't have to pay any tax on that gain.
That's right.
So we're really talking about situations where somebody owns a capital asset and they're going to sell it, let's say initially during their lifetime. What you're saying is that we're going to pay a capital gains tax, right?
Yeah, that's right.
So under the federal tax law, tell me a little bit about the difference between a capital gains tax and an ordinary income tax
Yeah, that's a good question. As you're aware, ordinary income is taxed at the highest marginal federal rate today is 37% when we're filming this podcast episode, whereas the highest capital gains rate is 20%, although if you have additional income, you might be paying a Medicare surtax, which is 3.8%. So our maximum capital gains tax is as high as 23.8% as opposed to 37% on ordinary income.
So not only do we get a little bit of a break on the sale of a capital asset compared to, say, W-2 wage income, we also have some other tax benefits with capital assets. Let's talk about what happens when we pass away and we own a highly appreciated capital asset. What does the tax law say about that?
With a highly appreciated asset, let's say that I own an asset that's worth $1 million today, but I only paid $200,000 for it, and I die holding that asset. Well, now my heirs, my beneficiaries, get that asset at its new basis, at the adjusted basis at the time of my death, $1 million. So if they then sold that asset for $1 million, they would recognize no capital gains tax. And contrast that where if I sold it the day before my death, I would have had an $800,000 capital gain to pay taxes on.
So one strategy with respect to folks who own a capital asset, whether it be stock or real estate, if they really are not interested in paying the capital gains tax, one strategy is simply hold the asset until you pass away and then have your heirs sell it soon thereafter, and that pretty well wipes out any capital gains tax.
That's right. But consider if I hold that asset jointly with my spouse. Okay, if I live in a common law state, there are 41 common law states. Ohio is one of them. Florida is another. Let's go back to my same example. I own it jointly with my wife, the $200,000 that we paid $200,000 for that property. I die and it's worth $1 million. Well, in that case, we only get a step up in basis on my half in a common law state. So my original basis on my half was $100,000. My half of the adjusted value at the time of my death is $500,000. So my half jumps up to $500,000. My wife's half still stays at $100,000. So what that means is if she sells it the day after my death, she still has a $400,000 capital gain.
That is a big deal.
Yeah, it really is, because so many married couples own their investments, they own their properties jointly. Now, contrast this with a community property state. There are 9 community property states. They stretch from Louisiana west to California and up to Washington, with the exceptions being Oregon is not a community property state, whereas Idaho is, and Wisconsin is also a community property state out there in the Midwest. So in any event, if I live in a community property state, same set of facts. Wife and I bought the residence for $200,000. It's now worth $1 million. I die. Only I die. She gets a step up all the way up to $1 million in a community property state. So she sells it the next day after my death, no capital gain at all, as opposed to residents of common law states, Ohio being among them. She would still have a $400,000 gain on which to pay tax.
You know, Craig, some might say the unequal treatment from a community property state to a separate property state doesn't make sense when we're dealing with federal law, because shouldn't federal law be the same for all 50 states? How is it possible that it can be different?
You know, that's a great question. And you would think that it is a federal law, so we would all pay the same tax, right? But here's the thing. A lot of federal tax law is state dependent, how the state treats the asset. So, and this is where these community property opt-in trusts come into play. But in any event, the IRS says, well, if the state treats it this way, we'll treat it that way as well. And that's where, you know, you have a federal government of 50 states, and each state has their own laws. So in some respects, state law can affect the federal tax law.
So here, both your state, Florida, and my state, Ohio, are separate property states. We're not one of the community property states, correct?
That's right. That's right.
So, so tell me, if you're in Florida and you're a separate property state, now all of a sudden we're introducing a community property option into Florida law. How does that work?
Yeah, well, actually, Florida is the fifth state to enact a law like this. Alaska was the first about 26 years ago, and then South Dakota followed a few years after that, then Tennessee, Kentucky, and now Florida. And what these five states have decided is they want to enable a resident of a common law state, like Ohio, like Florida, to get the same tax benefits as a resident of a community property state. So they created this law where you can create a community property trust and then put those assets in that trust, and you get community property treatment under state law. And because you get community property treatment under state law, you end up with the community property benefit under the federal tax law.
And that community property benefit includes either a step up, or I suppose we should also mention potentially a step down in the value.
Yeah, a lot of people think everything's a step up, as you point out, but it's really what the tax code says, and the code section's 1014. And what it says is an adjustment to fair market value at the time of death. So in most cases, that's a step up, meaning that it is adjusted upwards because it is appreciated in value. Excuse me, if the asset is depreciated in value, it could be a step down.
So let's talk a little bit about this trust concept. Is this a revocable trust? Is it an irrevocable trust? What does this trust look like? And who can create it? Who can be the trust makers, and who can be the trustees of it? What does it look like?
Yeah, that's another great question. Now, in some of the states, and these states are the ones that have domestic asset protection statutes, like Ohio's. I think it's Alaska, South Dakota, and Tennessee. Their trusts are by default irrevocable. Okay, Florida's is by default revocable. So unless you make it irrevocable, it's a revocable trust, very similar to any joint trust that you might create between a husband and a wife, or a husband and a husband. We have same-sex couples as well. But so long as it's a married couple and they create the trust and they opt into this community property treatment. Now, one of the things about opting into community property treatment is the fact that you have, let's say I have a nuptial agreement with my spouse. And let's say that it says on divorce, I get 70% and she gets 30%, or we have some kind of financial arrangement that's different than what would otherwise be community property, which is 50-50. So if I put these assets into a community property trust, all five state statutes are similar in this respect. It's treated as community property, and any other agreement that you may have had about these assets that you've transferred in is no longer applicable to lease those assets. And there's creditor rights issues as well that we can get into.
So when you're forming them in Florida, that's an interesting option. Are you doing both revocable and irrevocable, or have you gone one way or the other?
The ones that we've done for our clients are mostly revocable.
Okay.
Because unless we're doing some estate tax planning, we want to make. But here's the problem: when you make them irrevocable, then you have to somehow trigger the step up in another way through, let's say, an intentionally defective general power of appointment, which is a technique that you use to give the spouses the right to direct the assets. So, the irrevocable trust segment of it is usually in a domestic asset protection trust type of a scenario, which that's a law that we do not have in Florida. We've tried to get it several times, but the bankers lobby and the personal injury lobby is very strong in Florida, and we haven't been able to accomplish that. But yeah, in direct answer to your question, most of the ones we do are revocable.
So in that case, if you have a married couple, who's the trustee?
Oh, the grantors are usually the married couple themselves, and the trustees can be the married couple, just like a regular revocable trust.
And do you find that it oftentimes will mirror the provisions of their standard revocable trust?
Yeah, and in fact, in many cases, what we've done with our clients is it just replaces their old joint trust. The only time, again, that we normally worry about a different scenario is when we have assets that the couple want to keep separate and distinct pursuant to some kind of a nuptial agreement.
So are you ever in a situation where you're creating a separate opt-in trust for a husband and a wife?
Yeah, but it's less common.
Yeah.
Most of our clients, it's their foundational document is the opt-in trust, the community property opt-in trust. And it's the foundational document because, most of our clients have the same beneficiaries. They've been married a long time. They don't have a nuptial agreement. So for that couple, a community property trust is ideal.
So give me some examples of the types of assets that individuals who have come to you have placed in this community property trust.
Residences, both inside and outside of Florida. Their investments that are not in IRAs.
Now, before you go on,
Yeah.
I thought we had an exemption that applied to our residences that wouldn't be needed for this kind of scenario.
Yeah, what you're talking about there is a Section 125 exemption, which is the when I sell my primary residence, that's been my primary residence for 2 of the last 5 years, then I have an exemption of $125,000 for an individual, or it's $250,000 for an individual, $500,000 for a married couple. But let's say that I have a home that has appreciated beyond that $500,000, right? If that's the case, the community property trust helps out in the sense that we eliminate all of the capital gain, not just $500,000 of it.
So we're really talking about households where they own a residence that simply is over 500,000, which is pretty common.
Well, over 500,000 in appreciation.
Yeah. Got it.
Yeah. And that anybody who's held their home for a long time, might be bumping up against that or over that, depending upon, where they are and so forth. But it's residences both inside and outside of Florida. You could have a residence anywhere and put in a community property trust. In their investment accounts. And again, they don't have to be in Florida. It can be anywhere, the investment accounts. Depreciated property is another great example. So if I own a strip center and, then I can get community property trust treatment on that. Now it gets a little bit more complicated if it's inside a partnership, which a lot of those depreciated properties are in, commercial properties are in. But almost any kind of property is a good idea to put into an investment into a community property trust. Fascinating.
Now let's talk a little bit about its application in particular to Ohio residents. How is it that, let's say I happen to represent a lot of farmers, and our farm values in Ohio have just skyrocketed. I have clients of mine who paid $1,000 an acre. And today the land is selling in excess of $25,000 an acre, and they own 500 acres.
Yeah.
But typically, in our farm scenario, our farm couples, they own everything jointly. And I will say this, oftentimes the husband passes away first, and the wife is there, and she wants to sell the property. And sometimes she's selling it maybe to a grandchild or selling it to a neighbor or something like that. How would an Ohio resident, maybe who owns a farm, how would this work? How and why does it work for an Ohio resident to be able to create a Florida trust? Is it really possible for somebody from Ohio to create a Florida trust?
In theory, it is. Now, Alaska's had these statutes for 25, 26 years. And most of the people establishing Alaska Community Property Trust were not Alaska residents. They were
Sure.
residents of other states, because of what Alaska did in trying to do this, and South Dakota did, and now Florida. The idea is to try to attract investments to the state. Now, what Alaska did, and many of the other states do, is they say you need an Alaska bank or trust company to serve as a trustee. And that's how they invite the individuals who want to use Alaska law to their benefit, and that's what benefits Alaska. Now, in Florida, for example, you can name a resident. You need a Florida resident or a Florida trust company or bank or national bank as a trustee. So that's the one catch that an Ohio resident would need, is they would need somebody in Florida to serve as a trustee. But so long as they had that, then they would qualify under the Florida Community Property Trust statute. They could put their Ohio farmland in it and then achieve community property status.
And that seems pretty straightforward, pretty easy to do. Any controversy about that at all?
Well, commentators have suggested that the IRS may challenge it, but remember that Alaska statute's now 26 years old, and I'm not familiar with any challenges to it from the federal IRS. One of the sticking points that some of the commentators suggest the IRS might use, if they were to try to use it, is the creditor issue. In normal community property states, a husband and wife are liable for each other's debt. So a creditor, like if I'm a doctor and I own community property with my wife, okay, and I have a liability to a judgment creditor, they can attach to our community property assets. Now, Florida's statute says, for example, that the only assets that are subject to that individual's creditors are that individual's share of the community property. So, there are some differences legally between a community property state law and how community property normally works, and these community property statute laws. And there is no uniform community property law out there. So these states are drafting their own statutes, and they're very different from one another. Kentucky and Tennessee's and South Dakota's really are quite simple. They don't really go into much. Florida's is much more in depth. Florida's a more recent one. What Florida does, interestingly, with creditors, this is interesting too, is an independent trustee, not one of the grantors who are trustees. So husband and wife, even if they're serving as trustee, they can't do this that I'm about to talk about. But what an independent trustee can do is allocate certain assets as satisfying the community property share. Now, in Florida, there's a Florida homestead exemption that's very, very difficult. Creditors generally cannot get to your Florida homestead. So let's say if that's your primary residence, that's your Florida homestead, it's your primary residence. Let's say that you have $1 million of residence and $1 million of investments. Well, the investments a judgment creditor could easily get to, right? But what the independent trustee could do is say, well, the husband share, in this case, I'm saying the husband is liable, is the homestead, and wife's share are all the investments. So they can play some games under the Florida law with creditor protection. And even though Ohio residents don't have a Florida homestead, because by definition they're Ohio residents, they could still play games. For example, if they have assets that are in an LLC that are harder for a creditor can get to under the Florida statute, you could allocate that interest to the debtor spouse. So there's some creditor issues, but again, the IRS has not brought those up. And an Ohio resident is free to use the Florida statute if he or she wants to.
Fascinating. So when we kind of wrap this up, for those clients who have highly appreciated assets, who own them in a husband and wife, probably a long-standing marriage, who want to take advantage and give their spouse the option of being able to sell that appreciated asset after one of them dies and not pay any capital gains tax. This seems like kind of an ideal solution for those couples.
Yeah, to me, it's a no-brainer because let's assume that the IRS actually challenges the community property status for some reason. Where are we? Well, the couple's put back in the same position that they would have been in. They're still going to get a half step up in tax cost basis. So the only thing they're really out is the legal fees and costs associated with the establishment of the community property trust. But again, I haven't seen anything, where the IRS is challenging these. That's not to say that someone's going to be the first at some point.
Well, and I think on top of that, you and I both understand that in the community property states, the step up at the first death is automatic and the IRS has never challenged that.
Yeah. So what I'm talking about is the full step up. They have to challenge that.
Yeah.
But my view is it's worth a shot because you're put, even if it fails, you're still in the same position you would have been otherwise. And if it works out, you've eliminated a substantial amount of capital gains, which then frees, I have some clients, I'm sure you do also, Ted. I'll give you an example, right there in Ohio, Procter & Gamble. So I had some clients who owned a lot of Procter & Gamble stock because they worked at Procter & Gamble, and a lot of it was outside of a qualified retirement account. It was just investments that they owned. And all their financial advisors were urging them to sell some of it because they were overweighted in one stock, and they wouldn't do it not only because they thought it was a good investment, but because they were afraid of paying the capital gains tax. They didn't want to pay the capital gains tax. Well, if you put all that Procter & Gamble stock into a community property opt-in trust, and then one spouse dies, the surviving spouse suddenly has the option of diversifying if he or she wants to, whereas before they would have paid a lot of capital gains tax to accomplish that.
Great. Let's shift gears a little bit. We've got some changing landscape that may be happening over the course of the next couple of years with respect to the federal estate tax. When I started to practice in 1986, the federal exemption amount, that is the amount that each one of us could pass tax-free to our children, was somewhere around $600,000. What's the exemption amount today, and what changes are we looking at coming down the road here?
Yeah, the exemption amount today is what's over $13 million, as I recall. What happens is the current law sunsets at the end of 2025. Which,
when you say sunsets, what does that mean?
What that means is it was an act passed by during the Trump administration in 20. What was it? It must have been
2017, 2018, somewhere in there.
Yeah, it was passed through budget reconciliation, as opposed to what it would normally need is 60 Senate votes to get to pass. It didn't have the 60 Senate votes to pass, so the only way they could do it is through budget reconciliation, which is at a maximum 10 years. And you're thinking, well, why didn't it go to 2027 when the law was passed in 2017? I think it was the Tax Cuts and Jobs Act is the name of the statute. But in any event, the reason it only went 8 years is because under budget reconciliation can only increase the deficit by so much. Okay. So it had to be stopped at 8 years. So what happens is the law that has these huge exemptions now for us, more than $26 million between a married couple, is now sunsets at the end of 2025, which means it goes back to the old law, which is the law that they passed during the Obama administration, which was basically $5 million exemption per person and then adjusted to inflation. The pundits believe, based on the inflation numbers, that it will fall somewhere between $6 and $7 million to each person. So in other words, between a married couple or even for an individual, the exemption amount will roughly half It'll be cut in half between on January 1st of 2026.
So if I'm a single person and I have an estate worth more than $7 million and I am going to, and let's assume I pass away after January 1 of 2026, you're saying we're going to pay a federal estate tax. And does the rate change as well?
Well, the rate would go back to the Obama rates, and I think which is 40% is the top rate, as I recall. But
so we're going to pay a federal estate tax of some amount over the excess over the $7 million exemption amount for a single person.
That's right. Now, what most wealthy clients should consider between now and the end of next year is to use up that exemption, the $13+ million exemption, before it expires, because that exemption is not just an estate tax credit, or exemption. It's a gift and estate tax exemption, meaning that my exemption covers gifts that I make during my lifetime, as well as the transfers that I make at death, and it's one exemption. So if I use it all up during my lifetime, then there's no more left at my passing. Now, these are gifts above what we call the annual exclusion amount, which today is $18,000. I can give $18,000 to anyone I want, and it's not counted towards my gift tax exemption. But once I make gifts above that, then it's counted.
So the lifetime exemption amount is over $13 million today. It's going back to roughly $7 million on January 1 of 2026. Do I understand that right?
Yes.
So the opportunity each of us has is, if we have an estate that's valued above that amount, between now and the time the law changes, we have the ability to give away during our lifetime that $13 million. And you're saying if we do that, even though the law is going to change in 2026, we're still going to be okay. They're going to recognize that gift that we're making, perhaps to a trust for our spouse or for our kids.
That's right. I just verified, I looked it up. It's $13.61 million in 2024. Last year it was 12.92, so it's going up significantly. Probably will go up again next year. But yeah, you're right. Once you've made that gift, it's outside of your estate. Now, there are certain types of gifts that can be clawed back if they're made within 3 years of death. Insurance is a common example of that. If I have a life insurance policy and I put it into an irrevocable trust. And that's another point. When we're making these gifts, they should be either outright or in a trust, an irrevocable trust, if the grantor has the power to, have the income off the gift. Generally speaking, there's some exceptions to all this. Has the power to direct it, has the power to receive the income off the gift, then it's not really a completed gift. Excuse me. It's not really a completed gift for gift and estate tax purposes. So you would do this, and I suggest all my clients, let's use an irrevocable trust. And the other idea is to use up not only your gift and estate tax exemption, but there's something called the generation skipping transfer tax exemption. Now, this doesn't mean that you're skipping your children. What it means is you're skipping your children for gift and estate tax purposes. In other words, if I created a trust for my daughter and the trust is designed to go on for her children's lifetimes after her, the gift is, and if we apply my generation skipping transfer tax exemption to it, then at her death, no matter what that gift has ballooned to, might have doubled in value over the course of her lifetime, it's not included in her estate for estate tax purposes. So the generation skipping transfer tax exemption is equally as important to your family as is the gift and estate tax exemption.
Well, that's fascinating. So it sounds like we have a lot of planning opportunities over the next couple years here to try to do some estate tax planning for those clients who have a substantial wealth above and beyond the $7 million if you're single or $14 million if you're a married couple.
Yes, certainly.
Well, Craig, it's been great having you with me today. I really appreciate your insight, your expertise. It's really insightful. I learned a lot. Thanks for being with us.
Well, thanks for having me.